Good evening, everyone. Why does the Constitution need to be changed? Well, your Council's considered view for some time now has been that it's no longer fit for purpose. It was revised in 1980, but it's pretty much as it was when the Society was formed back in 1949. And at that time, there were perhaps 3,500 members, almost exclusively practitioners in private practice in what would be recognised then as traditional firms. Now, in the 21st century, with a profession of over 10,500 members, nearly 30% of whom are employed out with private client work, both the profession and the society really need to have more modern and flexible rules by which to govern and organise its business, and to be accountable to that diverse membership. Your Council was considering such changes long in advance of the Legal Services Bill coming forward, but now that that bill is complete and several of its proposals require to be incorporated within the original changes, we now need to complete that modernisation that was embarked upon, I guess, really nearly two years ago now. What started, though, as a simplifying, modernising exercise to put matters into clearer language and to overcome some of the challenges of interpretation within the existing Constitution, has really developed into a fuller examination of more fundamental issues, several of which were uncovered by the Council members who were working in the working group that was advising the Council on this matter, but also from members themselves in the various consultations that have been out over the last 15 months or so. Much wider scrutiny, continuing information coming back on all of this project, and that's been extremely helpful, and we're all very grateful for the observations and the contributions that members have made as we've gone through this work. But what's to change? Well, the size and composition is really the thing that's going to be changed. Primarily to, as Philip has mentioned, permit non-solicitor members of Council, perhaps up to 20%, and to provide for the establishment and authority of this new regulatory committee, which needs to oversee a range of powers across admissions, professional standards, and the discipline of members. Philip's already mentioned that the specific position of that regulatory committee under the terms of the bill, and it's something we'll return to. How is this being done? Well, as I said, many of the proposed changes are simply a tidying of procedure and translating, we hope, into plainer language the convolutions of earlier versions and amendments that have taken place over the years. And that's paralleled by the changes and the simplifications, the consolidation that we're trying to bring to the rules too, which again will be discussed in greater detail later. However, a key issue in terms of change is the size of your Council. Now, Council has spent considerable time debating the form of any different or changed Council from its present format. In fact, we spent 2 days in this building about 15 months ago working through these sorts of proposals. But Council has consistently argued that the majority of any new Council needs to be members elected from geographical constituencies, representing members across the country. The model that we've consulted upon allows for up to 36 members from geographies across Scotland, changed from the historic Sheriffton models that are explicit within the present Constitution, but still achieving effective numbers from all across the country and attempting to avoid over-concentration or overemphasis on any one particular area or another. Now, the Council was indebted to Ranald Lindsay, former Council member from Dumfries, for a considerable amount of work he did on modelling different types of different sizes and different formations of Council number. But they've all culminated in this approach, which still seeks to maintain this direct elected link between Council members and their constituents, real representation, while bringing the flexibility of additional co-options, up to 12, for underrepresented areas of the profession, either sectors or geographically, and introducing the up to 12 non-solicitor members to represent the public interest that the Society has an equal duty to protect, as well as the interests of members. As mentioned earlier, we presently have 4 lay observers who've made an invaluable contribution to Council's thinking and the debates. But it's unusual now, really, for any body with public duty not to have full public interest members, and it's time for us to accommodate that model. There also needs to be better clarity over the role and powers of the Council, the Board, other Council committees, and the delegated authorities to be vested in each of those areas. The Society, the Executive too, needs to be clear as to what authorities it has under the Constitution. And the standing orders of the Society, which are in the gift of Council, will also be amended to provide more efficient management of business at general meetings and improve voting procedures, enabling greater use of electronic means of voting and communication around all of those meetings. Now, when's this to happen? There have been, as I say, 2 formal consultations on various elements of these over the last 15 months, and we're now about to check on the final strength of feeling around some of the more significant details by means of an online survey that asks specific questions on, for example, the number of signatories to call meetings, proposed business at meetings, and so on. These changes and improvements are all intended to improve the effectiveness of the members, you, to hold your council and representatives to account, while reflecting the altogether larger and more diverse profession that the Society now represents and regulates. Final versions of these constitution, transitional provisions, and so on will come to your council at the end of this month, and for final sign-off in January, before an AGM in March of next year. That's sort of the traditional time for AGMs. They've shifted a little over the last couple of years into the early spring, but we're going back to March for that. And at that meeting, members will be asked to approve the new constitution and transitional provisions that we require to commence the electoral and selectoral processes to go forward to bring this new council into being in June of next year. Now, Philip will mention later on that there'll be another special general meeting, probably in May or June of next year, specifically focused on rules changes and the consolidation of rules, which again need to be adopted by members. So I'll just conclude by saying that this online survey on a number of issues that are still to be confirmed within the Constitution and Standing Orders will commence next week, and I'd urge you to complete it. There'll be an email coming out to all members to remind you to get involved with that if you can. It's a further opportunity for you, our members, to influence the way that these matters develop over the coming months. And I'd urge you to complete it if you can, and thank you in advance for doing so. Thank you.